full high def today. We're live here. Greg is looking good. Greg, did you get first cycle? Is that you just get back? Just relax?
No. Today was a Jewish holiday, so
that's right. Happy New Year! Oh my goodness, I forgot.
So I was busy with that today. I probably shouldn't even be on this, but we're basically done with our.
I will not tell the rabbi. Don't worry. I will not tell the rabbi. You and I had a very dear friend pass away recently who was Jewish. It was my first Jewish funeral. Thank you for the tips. But given the friend that passed away, it was a very joyous event. Hello, everybody. I'm Chuck Cook, Greg Siskin from Impact Litigation. We should be joined in a few minutes by Aaron. And if Greg gets out of the DMV line, he may.
No, it's Aaron, I think, at the DMV.
Is that who's at the DMV?
I think he's there. I'm here.
Yeah, I think Jeff's at the DMV. I don't know what he's bringing. He may be bringing one of his daughters. I'm not really quite sure, but we wanted to get with you because last week, the judge in Milligan issued his decision. Now, Milligan was one of the very first cases we brought last September, challenging the refusal by the government to issue K-1 fiancé visas because of the proclamations. Now, also included in Milligan was a mandamus, a challenge to the government taking too long to adjudicate cases. In January, we won the first argument where the judge said, you can't not issue visas. That's not how this works. And literally shortly thereafter, the department had caved and issued a blanket exemption to K-1. So the K-1s, now here's what's great, Greg. They still think they can deny visas. They still believe they can deny visas with an entry ban, but they gave an exemption. It's all NIE thing. It's just a house of cards. Just gave an exemption, and they convinced the judge that no, we would never revoke that. What? Why would we revoke that? Greg, I got this question: if Trump had won the election, what is the chance that the Department of State would have issued an NIE?
None.
Zero. So what is the chance of repetition? I don't know. What's Biden's chance of losing the next election? Pretty high right now. So, I mean, but the judge believed that, they're not going to make that same mistake again. That won't be a problem. So ultimately he ruled it was illegal, but because they fixed it, there's nothing left to argue about. It's moot. It's moot. Mm-hmm. The second part of our argument, which the judge did not rule on in January, he intimated it a little bit, but he didn't rule on it, which was they're taking too long. We are almost a year from when we filed our lawsuit. Now, in the Milligan context, I think over 90%, maybe even 95%.
Closer to 95%.
95% of our plaintiffs got their K-1. So we basically forced them to issue the visas. And we know a lot of people that were not members of our lawsuit didn't get their visas that, frankly, were kind of ahead in the line. But we know there's a group of people that did not get them, mostly Manila, but a couple from other countries. So we continue to fight the Milligan case. And I think the judge was kind of hoping that everybody would be resolved by then, which is why he took so long to rule on this case. But when he saw that there was there's only like 5% of people left, I'm going to rule against these plaintiffs. So basically the judge, in his opinion, said there's 6 factors that the judge has to consider. These are called track factors. 1, does the time the agency's taking a decision, it's covered by the rule of reason. Well, what is the rule of reason? That means they have to adjudicate cases in a reasonable period of time. Well, what's reasonable? The government never argued that 3 years is reasonable. What they argued was COVID. COVID made us take longer. It's COVID's fault that made us. But the judge did not demand from this. This is one of the reasons I was upset. We never had an oral argument on this case. Is, well, how did they respond to COVID? What did they do to respond to COVID? They just closed down. They didn't make any accommodation. But the judge said that's okay. Second thing is Congress provided a timetable. Well, I think we had pretty good arguments that Congress has implied a timetable, but it is true that there is no official timetable. Okay, so take that for what you want. Next, are the delays reasonable in the sphere of reasonable? Well, that factor really didn't come into play here. Fourth factor, the court should consider the effect of expediting delayed actions on agency activities of higher competing priorities. Well, if family immigration is their highest priority, then why are they taking so long? The judge, he kind of waffled on that one. I think we kind of won that one. But then the judge said, take into account the nature and extent of interest prejudiced by delay. And the judge was like, okay, people coming back together, that's bad. And then the last thing is, did the court find any impropriety lurking in it? He didn't find any impropriety. So basically, the judge weighed the track factors, and he basically concluded them, yeah, 2 factors favor us, 3 others were against us, 1 is not relevant. And he just kind of weighed them and said, I don't, they should do it as soon as possible. Here's what the court said. Mindful of the unfortunate situation that some plaintiffs continue to endure, the court, quote, encourages the government to act on the remaining applications as soon as possible, just as it adjudicated most applications since the first opinion in this case. So what happened here? The judge said, you did a lot of the work. So now the bigger question, Greg, is, okay, those plaintiffs have received an email from us and we're inviting them to join the other pending lawsuits without charge. Not that we had to do that, but we think that's fair. And so we've got the case in London pending. There was a London plaintiff. There's a case in Brazil pending. I don't think we had any Brazil plaintiffs left in Milligan. And then we had 23, maybe even 22 or 21 now, Manila plaintiffs, which will add to Ramirez. The Ramirez case has a pending motion to dismiss. The Brazil case has a pending motion to dismiss. London does not. London, this thing's still out there, waiting on the timeline to get reached. So we're going to see what a different judge says in Ramirez. So the big question, Greg, is the new judge, because a different judge, is he bound by this decision?
No. I mean, this is just a district court decision, and the track factors, every court looks at the specific case that's in front of them to determine if they're met. So, the same judge, this same judge could get another case in front of him and come out with a different decision based on how he reads those same factors. So the track factors, that's precedent, and that will be something that will be examined by another district court judge. But this decision alone, I mean, there are decisions all the time denying people that are filing cases on these grounds on there, and they and you win sometimes, you lose sometimes on these particular issues, depending on how the judge applies those factors. In a lot of cases, the government just settles because it's easier for them to settle than it is for them to argue that, or they don't want to risk a loss. But that's we're not reading this decision as something that is going to have a dooming impact on our other cases.
And the set of facts to really look at. Oh, Greg, I have her sitting. Let's go this way. Here we go. A much better look for us. Lily. I don't know. Lily needs to be here. So all of my banners. Oh, there's my banner. My banners have disappeared. I didn't put up our Milligan banner, and she's going to kick my butt for not doing so. Go back and for the last 8 minutes and watch us talk about Milligan. More. But I want to talk about the Manila case in this context as an example. What's different about Manila versus Milligan is that Manila hasn't adjudicated 95% of their cases since it was filed. They've done jack squat since it was filed. That's, I think, a much more compelling argument, especially if we're going to add these folks in, say, look, it's been a year. They haven't been anybody. I mean, that is outside the scope of reason. And in fact, when we look at the facts of Milligan, where they adjudicated 95% of the cases and it was filed, all K1s, and they've done none in Manila. That's when the track factors go into our favor. So I think we have as a result of Milligan, actually have a really good argument in the Ramirez case. So
yeah, I mean, I think the thing about the Manila case is that Manila has been much worse than all the other consulates around the world on there. So you can't even, if you're just looking at this, argument about COVID, it doesn't explain why Manila and the Philippines, which really hasn't had any worse of a problem than other countries when it comes to, I mean, every country has their spikes and all that, but think back over the last year and a half, and you will not see, major news coverage of horrible conditions in the Philippines compared to other countries on there. So the COVID doesn't explain why Manila is doing so much worse than all the other countries. And I think that's hopefully the point that we'll be conveying.
So I think that's good in that regard. Other than that, we have no news. We have no other decisions on anything. So nothing in the Rio. We do have plaintiffs that are continuing to get interviewed in Rio, which is great. And that's where it's different. So Manila, they do nothing. In Rio, we've had a lot of plaintiffs that have been issued visas. So a judge might go, well, look at Milligan, kind of the same case. I'm gonna dismiss it. So I still feel confident that we're going to win these cases. And it doesn't mean that if in a year or 6 months they haven't done jack squat, you don't go back again and say, Judge, now it's 6 months later and they still haven't done it. What is reasonable at this point? So that's kind of where we are on all these cases. So, Greg, I did want to just briefly touch base on the Gomez Acker DV 2020 case. We have nothing from the Judge Mehta on the response that was sent in. And I bet you he is just pissed off, to use a phrase. That why? How could you not agree? And the thing is, it's not like we were negotiating from our side. The government literally took a position and said, we will not give you anything else. We will not move. We just won't. We won't do anything.
The government's position is essentially, we're not doing anything, Judge, unless you force us to. And that means you have to tell us specifically what you want. We're just not going to volunteer to do anything on our own, which should make the judge fairly annoyed, but we'll see.
And which means that we also have nothing in the go. Somebody asked me, aren't you upset? Well, I am not happy that we don't have a decision yet, but that's the way it goes in court. Hello, Aaron. How are you? You're looking good today.
Hello, guys. Sorry, I'm a little bit late.
About all how wonderful the decision in Go was. The one we don't have.
Don't scare me. Every time I'm away from the computer or my email for a few minutes, I'm wondering if it's come down. So,
we've got nothing there in Go yet. And I'm sorry, folks. It's DV 2021. Did you know that it's September 6th or 7th? Yes, I actually have a calendar at my office. I know exactly what it is. I still remain confident. I think we're in good shape on this case. And yes, I know the judge denied somebody else's class certification. Although I didn't read it, I got an impression from the tweets that they were denied it because some technical reasons.
Yeah. Let me talk about that first. Did you already talk about it at all?
No.
Okay.
No.
So there was a decision in Rosales which denied the motion for class certification and denied the motion for preliminary injunction. And the reasons were technical, and it was without prejudice, which allowed them to refile the motions. The problem is, I think, for the class certification is that the government still gets time to respond to the motion, and we're about out of time. There's not time for all of this to happen, or it's going to be close. But regardless, we should have our decision far before any of that comes down. And so that's what we're focused on. Is we still think, even after Gochi, even after what's happened in Rosales, we still think it's clear we have standing, and that our arguments are clear. And so we're just waiting on that order. I told some people by email that I'd take it as a good sign that there was some action in the other cases last week, because that means he's working on the DV 2021 cases. And so I'm hopeful that this is the week for the decision.
And I think the reason why it's a little bit different, but it was a year ago, 3 days ago, when we got the decision in the Gomez case. He knows this time. So last year, he had to order them to actually work. This year, he didn't have to do that. They told the court they were going to interview 6,000 people in August, September. And actually, I think they're interviewing more than that. I think they're more than that at this point. And so the final decision in Gomez didn't really come down until September 30th. I mean, and so he may be waiting. He may say, government, give me a status update. And so maybe he's going to wait and say, how many do I have to reserve? Because I think he wants, my guess is He wants to reserve a number, but he doesn't know what number to reserve unless he knows how many were issued. Now, of course, we want him to reserve enough for all of our plaintiffs, obviously. We'd love the reserve for other people too. That'd be a wonderful bonus. And we believe the order should be universal. And we've argued that everybody, that all these be issued. But keep in mind, as our friend Britt Simon has repeatedly said, not everybody's getting a visa, right? I mean, every country's got a limit, and they notify.
But we also need to sort of temper expectations, because it's still not known if we're going to win on there. So everybody just needs to be patient, but and also know that there's no guarantees here. Looking at Gomez, there is no difference between our cases, between Gomez and Go. The government clearly did not issue visas for 6 months for the same exact reason they didn't issue visas in Gomez. They didn't think they had to under 212F, clearly. So at least 6 months worth of visas should be reserved, at least 26,000. Now, don't know where he's going to go on that, but again, the key for us is getting as many of our plaintiffs the visas as we possibly can, and hopefully others get them too. And it's too late to join us. We're not signing anybody on. We're not that kind of firm.
So one of the emails that we get most often is from people who submitted their documents long ago, but KCC never documentarily qualified them. We know, the court knows, we've told them, and so that does not mean that you're locked out of relief if he reserves visas. That's just not what that means. They know, the court is aware of the KCC, that they weren't working for a long time. They're aware that people with higher case numbers have been scheduled when some of our plaintiffs have not. And so, we just have to wait and see what the order says and then take it from there.
Now, Aaron, we have notified the government that some of our plaintiffs, at least a few of them, who were documentarily qualified, were passed over in the numerical listing. Now, and the government's aware of it, but the judge is aware of it, but I don't think he's going to do anything about that. But keep in mind, it's not just the number. It's when you got, so they look at your number first. Actually, I don't think they look at it. I think they look at you who was documentarily qualified first. And that's the number. The idea the judge says assign them in random order. That's not how they assign cases. They look at documentary qualification, which is why if you're a DV 2022 and you're watching this and you won the lottery 3.5 months ago and you don't have your documents in, you're screwed. You need to get your documents in now. Don't wait for a letter from the KCC. Send your documents in now affirmatively after your DS 260. You want to be up at the top of the line for documentary qualification. Hopefully, we don't have to file another lawsuit for DV 2022. Because at least one person told me they have an interview October 3rd. So,
there's a possibility, by the way, that people should keep an eye on it, that there may be some language in the reconciliation bill designed to deal specifically with DVs on there. So fingers crossed.
Let's give a thumbs up.
Congress is going to fix this problem.
Wait a second. Did you say Congress was going to fix the problem?
It's been 16 years since they passed immigration legislation, but it's going to happen. Anything.
And I would guess that only 1/3 of the people in Congress were around the last time they fixed immigration. Yeah. And that wasn't even a fix. That was like a throwaway thing that they got done.
Yeah, it shouldn't depend on lawyers to fix these problems. Congress should be doing that.
I think the judges really, especially we'll get to EBAOS Delay in a second. Judges are like, why am I having to fix this? Why is this litigation here? Why? And that's a great question. Let's
By the way, we are going to have language, I think, by September 13th in the House bill. They're going to have their markup then. So we're only talking about another week.
September 13th is 6 days from today, which will be a Monday.
Yeah.
And with any luck, they will come out Monday during the day, and we can chat about it here in the litigation update.
Yeah, and I probably will live tweet the markup hearing if that's something.
Wow, that's something I'm going to stay tuned for.
You're not a
the
believer.
fact that you're watching hearing, Greg.
I think it's going to happen.
I am pegging the odds at 30%. If anybody wants to take that bet, 30% that they will do something, because I read a disheartening thing yesterday about it. So
yeah, I know. Every time it's counted out, it still manages to stay. So we'll see.
Yeah, I don't think this will be like The Godfather. Let's take a look at the EBAOS delay. This was truly one of the bizarrest hearings that I have ever attended in fact, it was the most bizarre hearing. We talked about it last week. I'm still flabbergasted by it. So, I did order the transcript, except the court reporter's on vacation this week, so we don't have the transcript. Should have it by hopefully next Monday. We can talk about it. But there were things in there that were said that will help a colleague of ours. By the way, did we hear from our friend Barry?
I have not heard from Barry today, but maybe you can explain what we're talking about.
All right. So a good friend of ours, a lawyer in Mississippi, filed a lawsuit on behalf of two families they're basically EBAOS delays, asking the court first to order the government to adjudicate the case before September 30th, and second, to reserve 5 visas for his clients if they couldn't get done. He had an initial hearing with this judge in Mississippi that he believed was favorable. And they had another hearing today, which we don't know anything about. As Greg and I were talking to him yesterday, obviously the simplest solution for the government, if they don't want to reserve visas and they don't want a decision on that issue, is to just issue 5 visas. Mm-hmm. And the government's like, well, we have to take them in order. Oh, yeah, because order is so important. Another argument just came out. If order is so important, why do you have 2 numbers on your processing time charts? One for the median and one for cases that take really long. Because you don't take cases in order. That's just literally published in the world that you don't. So what's going on in our case is nothing. The government filed their reply. I don't know if you had a chance to look at that, Aaron. I have not had a chance to review that. They sent it in on Friday evening, their response brief. Our reply is due this Friday to the court, and we'll be asking for a hearing from the judge on this case. Greg will talk afterwards about that reply that's got to get in. This is, I think we've got a really good arguments on this to reserving, but honestly, I don't even know if we're going to keep the same judge. I don't know what's going on with that. It's bizarro. Aaron?
The government did have some substantive arguments in there that we're going to be addressing, one of which, if you tuned into the hearing last week, you saw a lot of discussions regarding venue and whether these cases should properly be in Maryland. Now, I think it's a fairly easy answer, which is yes. That's where USCIS is, and the rules allow you to file where the government agency actually is on there. Our case is a little bit different than the other cases because we actually have plaintiffs in Maryland as well as a defendant in Maryland. So it makes more sense to sue there than it does in any other jurisdiction in the country because we have both in there, a defendant and plaintiffs. With that being said, we'll address that issue. And then they did make a I thought it was a half-hearted attempt to actually address the substance of our arguments. And one of which is, I think one of our stronger arguments is that the H-1B visa reservation language is identical to the adjustment visa reservation language, but they're interpreted in 2 very different ways on there. The government's response is essentially, so what?
So what? I love that response. Yeah.
Right. They say that they can do that because they're allowed to do that. So we'll have some pretty good arguments on why that is not in fact okay to do that. And I think that and then we'll want to see what happens in the Mississippi case because if the judge there orders a reservation of visas, even if the government ultimately approves these things before September 30th. That will hopefully be helpful as even though we just talked about why one district court's decision doesn't necessarily bind another, sometimes it can be influential, and hopefully that will be something we can use.
All right. So I'm excited about that. I think I'm excited for the oral argument in this case. By the way, I'm getting admitted on Friday, Greg.
There you go.
I'm getting sworn into Maryland on Friday. It'll be my 30th federal court or something like that that gets sworn into. So I'm looking forward to it. So that is that. The Kinsley case, we still waiting on the Kinsley case. We're still on pins and needles what the judge is going to do in Kinsley, which is a very different case now, because it doesn't just involve K1. So the Milligan is K1s, all right. So NIE blanket exception K1s. Kinsley says, there's no blanket exception for anybody else. So that part of the government's argument is gone. They can't make that argument in this case. Their argument is instead, well, we can do this. We can invent things out of whole cloth and then interpret them differently around the world and never give a visa. Thank you very much. Have a nice day. I do anticipate a different result in Kinsley, but we're still waiting. We're still waiting on that.
The thing about Kinsley is we have to have a judge essentially change his mind about what he previously said in the Milligan case. It's the same judge.
Right. But
right. So Chuck just explained to you guys that in Milligan, we won on the first on this question with the judge, in January, whenever the decision came out on that. And then he basically punted on the question of unreasonable delay. And that's ultimately where the decision was this week on that after all these months. But this other issue regarding whether the government can ban the issuance of visas under 212F, he made a pretty definitive ruling on that. Judge Mehta made a pretty definitive ruling on that in Gomez. We had a pretty definitive ruling on that in our 01 case. And there is at least one other case that wasn't ours, I think, where there was a similar judgment on that. And there haven't been any cases yet stating that where that issue, where the government won on that issue. So I'm feeling pretty confident that that's a winner for us. So hopefully Judge Boasberg, I think I'm a little puzzled why he's taking so long, because in this case, it's basically just issuing a decision on an issue that he's already researched and made his, and decided what his views are on it. So I have no idea why, other than that he just has it in a queue and he hasn't gotten to it yet. I don't know that you can.
He could be trying to figure out, how do I help the government by upholding NIE, while looking at my last argument, my last ruling that said you have to issue visas. He didn't say you have to issue visas according to something they create out of whole cloth. And he was very focused in the decision in Milligan about the blanket exemption and them never taking it away. It's as if what they're doing doesn't exist, whereas in Kinsley it still exists.
Right.
We'll see. We'll see in that. Greg, did you want to talk about the EAD case?
Yeah, I mean, I haven't had a chance to talk to my team today on it because I've been out, but the apps are all ready, I believe. I was getting little test messages on them. So I think we're going to open that up hopefully tomorrow to start taking on plaintiffs in that. I don't know if you guys may be more up to date on that than I am, even though it's
I am not. I have also been at holiday weekends. Do that to me, Aaron.
No,
if you signed up for that questionnaire and you gave us your email address, we will send you a notification with the link to the apps to get started. But look for something tomorrow on that. I'm pretty sure it's all ready to go, but I'm not positive.
We're going to be happy to refer to the transcript from Chakrabarty, where they say that they're already prioritizing EADs.
Yeah, which we know is, but at the expense of not doing 751s, which, by the way, turns out to be true. They just extended 751 receipt notices to 2 years, which is longer than it takes them to adjudicate marriage. It is illegal because you can file for naturalization 2 years and 9 months for your conditional card, and yet they won't naturalize you unless they adjudicate your 751, which is illegal to deny you naturalization. So it's completely illegal. And then the kicker for me, though, was, oh, you need a new green card? Yeah, we'll get to that eventually. Not that important.
I mean, the bottom line is that agency, USCIS, is in bad shape. And litigation's going to, even if there's people with good intentions to try to fix it, litigation's going to be necessary, unfortunately, for the foreseeable future, because these delays are just unconscionable.
It's just
they still have a lot of people in the agency who do not want to do anything outside of the way they've always done it in order to fix their problems. We're definitely seeing that with adjustment of status, where there's this whole internal debate about reserving numbers. I know there is, because I've talked to people senior at the agency where they are debating it internally. That's something that we're not just asking for this. That's something outrageous and unreasonable that lawyers are asking for. They've had this internal debate, and there's a big fight going on in the agency between the people that want to fix their problems versus the people that are saying, well, we've never done this before, and we might get sued by the Stephen Miller types on there. So it's like, that's what they're really afraid, that if they do anything aggressive to try and fix their problems, that they're going to get sued by conservatives.
In Judge Hannon's court in the Southern District of Texas.
Right. And that might happen, but that's not an excuse not to make changes that are necessary. At least if if you're trying and you lose in litigation,
all you do is get your proposed regulation effective immediately.
Right. And then it forces Congress's hand too, if that happens.
Crazy stuff. All right, let's ask some questions here. We got some questions. Will Ramirez plaintiffs be head of non-plaintiffs? Well, yeah, because we're only suing on behalf of Ramirez plaintiffs. So yes, Patrick, Ramirez plaintiffs are our only plaintiffs. Morning, Ahmed. Good to see you. Tori Wong, I don't know where she is, and it's the morning, or he is, but good morning. Dimitri, good to see you. Good morning, Joseph. And Thari, will there be any possibility to get access to the DS60 Form MDB 2020 winners? Yes, that actually is a great question, Thari. And according to the government, you would have 2 years to get that done. So yes, they have not confirmed it, but logic dictates that they will ask you to go in and update your DS260, because obviously people moved, as an example. Mashid, for Gulpland, any chance of priority and reservation? I'm going to count how many times we've been asked and answered this question. Oh, a lot. A lot. We fight for our clients to get their visas reserved. That's what we're fighting for. Okay. Hello, Mike. Good to see you. Thanks of Jochi and Rosales. I think you talked about that, Aaron. I don't know.
Yeah, if you missed it, go back to where the Go banner, and we talked about that.
Yeah, we talked about that. And this was early on. Rohit, AOS late plaintiff here. Sorry to have been asked earlier. It hasn't. You're the first one to ask it. Does it make sense in medical interjection? And Greg, the answer to that question is?
Yes.
Medical exam.
Yeah, I mean, just as a reminder, I've given this advice on other calls on there. If you've just gotten your medical, get the doctor to do 2 envelopes that are identical. Hold one for a request for evidence, and then you can try and send the other one in. And your lawyer has no doubt been hearing about different techniques that people have been using to try and get it linked up correctly to the file. Definitely, though, have one ready for an RFE in case that comes.
All right, so get your doctor to give you 2 sealed envelopes. His is, what if your party that's current? Dude, if immigration does their job, basically anybody with a pending application will be adjudicated by September 30th or sometime in the next 6 to 8 months. Because remember, whether we win or not, they're getting another 120,000 immigrant visas. And
right.
They will be hard pressed to face up in a lawsuit next year over the same issue if they don't do their job. So I would send it in. That's a good question.
Right. And it's important to note as well that our unreasonable delay claims continue after September 30th. We're arguing that they should do everybody by September 30th because there are no guarantees of what happens after that. In fact, in our hearing the other day, the government was actually talking about retrogression, which I do not know how that happens. But so we don't know what's going to happen after that date. And we also are, there's a policy argument that we're making that the government shouldn't have the ability to defy Congress and flush 80,000 visas, which is what's going to happen on September 30th. But yes, we will be, if your date was not current, we're still going to be arguing for you after that. And your date hopefully will be current after October 1st. Just keep in mind the filing date chart is the government's forecast last year of where they thought they were going to be on September 30th this year, that they were going to be finished. And they're still not providing us clear data on, where they are on that. But, hopefully with this extra 120,000 rolling over, that you will be current in October. Well, we'll see.
Yeah, Greg, you made a good point. When the government issues the priority date visa bulletin, it's because they believe they can adjudicate those cases within that quarter, within that period of time with the visas available. That's why it moves so far forward. We can adjudicate these cases within this time frame. And when they're not doing it, that's when the backlog occurs.
Right.
So that's kind of where we are. Great question, Rohit. Thank you very much. I already asked that question. Chromebox, any hope for visas issued but not expired? That's what we're asking for Judge Mehta. We asked that specifically in his clarification. So we'll see. And again, if he doesn't clarify it again, we will go back again and ask him to clarify. Volkan Setankaya, 2 judges denied 2 PI requests. Oh, we already asked that. No implications. Avanti, EBS, if EBAOS dealing in product lines, I don't understand that question. Oh, I think it's a joke. I'm not really quite sure. It says an inside immigration.
That guy.
Greg already answered this question. We believe that there is legal immigrants. I don't think the EAGLE Act is in it, but I think the act to reserve the visas is. So maybe the EAGLE Act gets in it. I don't know.
There's a lot of I wouldn't say that for sure that it's not going to be in there, but there may some of the other language that I've heard may be in there would largely make it moot, the EAGLE Act, or that it would have a much better chance of passing after this legislation.
It seems they took the plaintiff's case numbers to oppose them trying to process the cases. How can you insure? We can insure nothing. Federal court judges can insure things. We don't have that kind of power. But that's why we sued, to get these cases adjudicated by September 30th. Could immigration, Greg, adjudicate all these cases by September 30th? Sure. Sure they could do it. Absolutely. But Greg, they only take cases in date of receipt order, right? That's how they do that.
That's what they told us. And
we know that's true because wait a second. We know that's not true. We know that's not true.
No, they could, but they could do. I mean, they could settle with us and just reserve the numbers. I mean, you never know. There are people in the agency that would like to see that outcome.
I don't know why their general counsel wouldn't agree to it. It's a reasonable settlement.
Yeah.
Mike Holtman, panicking. Don't panic in Ramirez. We talked about Ramirez, go to the beginning. And no, there's nothing in the books that says you have to wait 6 years. That's absolutely outrageous. So we get that. Hello, AUS. Last year, AUS has stated that issuing EAD is priority for AUS applicants. Not true. Yeah, we know it's literally not true. What I really didn't like about either government counsel or the acting deputy director was like saying, well, they have work cards. They're fine. They're okay. They got a receipt. Every day they delay adjudicating a natural adjustment is a day longer it takes to become a U.S. citizen. It's a day longer till you can immigrate your mom and dad. It's a day longer before you have final security in the United States. They don't treat...
Oh, and by the way, a lot of these people don't have EADs. Either.
Right, of course they don't have EADs. I mean, that's the part of the problem, which means they're not really portable, which means they really can't go to a different employer, which means they really can't move on with their lives. And, and by delaying longer than 6 months, it complicates immigration's job, who now require a 45J to get another form has to come in. Another piece of information has to go in the file. Another 30 minutes of adjudication. I mean, they literally have developed a system that is literally a Rubik's cube of possible endings with no definitive date for adjudication. Okay. Liz, go. Congratulations, Liz. Got your appointment. Kick some butt. Is Rosales done? I don't know. I don't know enough about Rosales to be done, but I think they're going to refile, is what I heard. Why is Judge Mehta? We call him Judge Mehta. We don't just call him by his last name. It's Judge Mehta. It's a sign of respect. Why did he go? Because
this is a little different than the other questions. It's so the Gochi order was filed into Rosales and Goodluck on standing. So the U.S. attorneys in the Rosales case and in the Goodluck case made a new filing pointing Judge Mehta's attention to the Gochi order. They did not do that in Go. Why? I don't know.
Because it's not relevant to our case?
They're different U.S. attorneys assigned to the cases, and so maybe the one assigned to our case decided that our standing arguments are too good.
How do we not have standing? I just don't get how you not have standing in our case. I actually like what Almaz says here. I think all the people says, and your decision is perfect. I'm gonna say this. Aaron, you're like freaking Captain America. You're gonna say it. You're gonna be like Thor, who comes in as the god of thunder. Let's see. Mr. Siskins tweets, I will not defend Greg Siskins. Oh, no, I'm sorry.
What did I say?
You already kind of answered this, I think.
Yeah. Yeah, I don't have specific language. In fact, I did have some emailing around with the committee staff, and they claim that the language is still very much in flux. So we will see. I had been told by one source that it was basically ready, and then I've been told now that no, it's still in flux. So we will see during the markup. They have a deadline of the 13th to at least get something ready to start marking up.
Should be fun. Gagan Sharma, shouldn't all of us waiting for it should be included in the new lawsuit? Good question, Greg.
Do we make a decision on that?
I think what he's asking in the EAD lawsuit, should all the current EBAOS
should they sign it? Yes, I think we decided that was a good idea.
Okay. AOS plaintiff gone through the government reply. They keep saying 45 is discretionary. True, but not like, I don't like you, I'm not going to give it to you discretion. I don't want to go on a date with you. I'm swiping right or left. I don't know, on Twitter, Tinder, whatever the thing is. That's not the discretion they have. They have to have.
That would be capricious.
Yeah, exactly. They are basically required to favorably exercise discretion, absent serious countervailing evidence. That's the standard. So that will address that in our reply. K1 Moscow, joining the judicial file, we say, no, I still think Ponomarenko is a very different case. There's no consulate. There's no consulate. This is not like the Milligan case. There's no consulate. You can't. How can he say, well, you can just have no consulate? That's okay. No, I still feel very confident in the Ponomarenko case. Video update, Chakrabarty, chances of court hearing versus direct judgment. Oh, that's a good question. Well, first of all, I think I'll do the court hearing. What do you guys think? After, of course, the judge thinks Jeff is Mr. Green, so I think.
Can I comment real quick on what that last question regarding the about confidence? Just a reminder regarding Milligan that the judge basically told the government to adjudicate these cases over much of a year, where 95% of them got adjudicated, and then at the end he dismissed at that point. If we got something like that in Ponomarenko and in the other cases where we got 95% of our folks adjudicated, I would consider that a pretty good result.
Yeah, I mean, not for everybody, but we're working for everybody and all of our clients. All right.
No, I understand that, but I mean, it's like that's, you have to remember what happened in Milligan was after the judge issued this, after 95% of the plaintiffs got their.
We forced them to change their rules. I mean, we literally forced them to change it. So this is a good question. I don't know what the judge is going to do. Obviously, he likes hearings, and I mean, I would like to be in front of the judge in a hearing. I'd fly to Maryland, although he might not want to see our faces. But I think we're going to have really strong arguments on this. I think feel really good about it. Nicholas Coyle, K1 visa got approved for Milligan. Woo! Self-uniting marriage and no wedding official. I have no idea what a self-uniting marriage is. Do you guys?
Well, we have something similar in Colorado where you don't have to have witnesses or an officiant or anything. You can just sign your own certificate, and if it's good enough for the state, it'll be good enough for USCIS.
Do you have to be smoking marijuana while you're in Colorado?
Don't slander our state.
For all of you people, you should Google marijuana in Colorado, and you'll get my joke. If they can do video interviews in Afghanistan, why can't they do them for everybody else? Greg, this got under Greg's craw. So when they literally tweeted out a picture of them doing a video interview from TravelGov.
It just doesn't make sense.
How is U.S. adjudicating if they're willing to waste all of these visa numbers? They hardly adjudicate any applications in October. Yeah, well, I agree. I mean, so they did 80,000 green cards between October 1 and June 30. How are they, and she said they're going to do 180,000. How are they going to do 100,000 in 3 months? And what does that say about their system? The other thing, Greg, that's really frustrating is we know from their own report that half of the pending EBAOS cases are in district offices. Only half are at service centers. And I don't know.
I was pretty galled that they basically scapegoated the Afghans and the refugees as the excuse for not doing their adjustment work. It was disgusting, in my opinion, that they tried that.
Awful. By the way, I just read today about 45,000 Afghans have now arrived in the United States. Good. And we should be doing more to help these people, our friends, adjust to life in their new country. By the way, before you joined, we were a duo, Aaron, so don't be offended. Consequence, Kinsley based on we already talked about that. I hope that Francois, you got our answer. Now that they are asking, are you going to read the file in every plaintiff's? No, of course we're not going to do that. I don't think Chakrabarty I don't think he can move our case, honestly. And honestly, we could refile it in an hour in DC and ask for an immediate hearing. Punto. But it's just not necessary. We as Greg noted,
and then the government will move to, and then we'll see the government try and move it to Maryland.
Yeah, the judge, I don't know if he truly understood when Jeff made the point. Judge, they're moving the cases to your district from DC because the agency's housed there. I don't think he got that. Let's see. This is one of my favorite questions. Why didn't they process Afghan cases for 4 years? Great question. One we have asked. I mean, I have sued a number of times over SIV visas for Afghanistan. They had a little puff piece today on the Times or something. All these consular officers had to flee the consulate, blah, blah, blah. You know, I got zero sympathy for these guys. They could have been doing this stuff for a long time, and they just played games. They didn't. I think it's management incompetence. I don't think it's necessarily the officers. Massive management incompetence on this issue.
Yeah. I know you have pro bono cases, and we do as well, 5 of them. And the State Department has been very unhelpful in all of our cases. USCIS is not much better, but a little bit better. But the State Department has just been really disappointing.
Hey, that seems consistent with what we've been doing for the last 2 years. Well, I go to the beginning. We talked about going out. Go about the 10-minute mark. EB5. Greg, give us an update on EB5 reauthorization. So that you all know, Greg is well connected in DC.
EB5 reauthorization probably. I mean, September 30th is going to be a very critical date, even though that program expired at the end of June, because there are 3 other programs that expire at the end of September. One for the doctors, one for religious workers, and then the E-Verify program, which is very popular with Republicans. And they all have to be extended by September 30th. The EB5 folks are trying, I think, they used to be part of the 4 that were tied together, and then they separated them out basically to force USCIS and Congress to make changes to that program. But that, alas, it's September and we still haven't seen EB5 legislation. So if I had to bet, I'm going to bet that EB5 reauthorization is going to be in that same language that we're going to see for the other programs. Now, there is a discussion of including the extenders in the reconciliation bill that we're looking at as well. But if not, they will extend those other three programs, and the odds are, I think, if I had to guess, I would say 2-1 that EB5 will be included with those other three programs for extension.
Greg, can you believe we're actually having this conversation? This is ridiculous. A program that brings literally billions of dollars into the United States and creates thousands of jobs. They're debating whether they want to do it. It's truly stupid. Truly stupid. Great question here. Well, first of all, keep in mind, USCIS does not move the visa bulletin. That is done by Charlie Oppenheim at the Department of State. So he has to decide whether they move. And so he what he does is he calls USCIS and says, how many pending adjustment of status cases do you have? And how many I-140s in every category do you have approved? And then he does the math to move the bulletin. Now, you may recall that the August, for like a year, the visa bulletin, they said that the visa bulletin used to come out like clockwork, the 10th, the 11th, 10th, 11th, 10th, 11th, right then. And then later in the Trump administration, the 20th, 25th, 29th.
Well, because the politicians were, the White House were interfering.
In a couple of years, so in February, March, April, the visa bulletin started coming out again quickly, 10th, 11th, 12th. August didn't come out on the 10th, 12th, 15th. I think it came out like on the 18th or 20th. I would expect the same. I bet you, if we were going to take bets on when the visa bulletin is going to come out in September, I would bet late in the month.
Let me ask you a question, both of you, on on something that's been kind of concerning me. So last year, obviously, we had the two charts came out, and we saw some advancement in the regular final action date chart, but a considerable advancement in the date of filing chart. That's why we got all these applications. Charlie is going to do two charts again. He does them every month. What do you think the odds are that USCIS will accept a date of filing chart in October versus not doing it? And that is what really, is worrying me, is that they know that people were really upset that they didn't get the number adjudicated that they had, and that they might just, these same folks who basically just want to sweep problems under the rug, that they will not accept those applications because they don't want to have to deal with the pushback when next September rolls around and they have an even bigger number left over.
You can't have a backlog if you don't have the cases.
Yeah. I'm really concerned. So that's something for people that are watching. If that happens, we need a pitchfork brigade basically to pressure USCIS to accept those cases, because they will have the option to do it. And I am going to guess that they are going to try and screw over as many people as possible by not accepting that chart. Just a guess, and I know some USCIS people are probably monitoring this YouTube, and you've been called out that we on this issue now on there. But if you don't accept that chart, then we know that your priority is not to get these people green cards.
And we will not let the Biden administration forget that, FYI. Great question from Michael. Can the judge work behind the scenes to push adjudication? Well, no. Literally, his case is closed. But in the final wording of his order, I think I read it before, he says this: mindful of the unfortunate situation that some plaintiffs continue to endure, the court, quote, encourages the government to act on the remaining applications as soon as possible. I think that's a big push. We'll see. Somebody reading the government response to our PI, it's scary. They keep mentioning there's no guarantee. Yeah. Again, we'll deal with that on the discretion issue. Let's see. We only have a few minutes left. How did USA's claim to not have enough staff to process EB cases, but they seem overstaffed to process FMLA cases? That's a great question, Yogesh. Now, they haven't done.
I think the thing that we argue is that it takes less than 2 hours to adjudicate these cases, and they have a $1,200 fee. What are they doing with all of that money?
Oh, they're designing a filing system electronically. Oh, wait, that's how they lost $1 billion.
They have plenty of money, and it's not that much work. They should be on a hiring spree and deal with this, and they have not explained why they can't get it done.
You know what they didn't explain, Greg, is where the money went. They made a couple $100 million in October and November. Now, the funny part of that, her testimony, we didn't open our mail. That's why we didn't have any money last year. But there's a hiring freeze right now. They're not hiring people. But as far as the family and employment, the vast majority of family-based adjustments are adjudicated at local offices. And up until recently, most EB cases are adjudicated at service centers. So it could be that service centers are less efficient than local offices. I don't know. I mean, immigration is opaque on this issue. Well, it'd be really great if one time we could bring in a former senior ICE official, a CIS official, that it could explain this to people. I wonder if we can get anybody go on the record. What do you think, Craig? Do you think somebody go on the record?
Maybe.
I think so. That'd be kind of fun. This, by the way, Manu, is you're right. I thought it was. Audacity is a great word. It's okay. It's fine. I think audacious is, I thought it was unrighteous as well to say something like that. All right. What is your advice for me that I recently submitted the EBAOS prior date? How can you help us? If you only recently submitted your adjustment application, then you probably should sue them when you don't have it in a year. That's what I think. So there you go. That's our questions for today. I want to thank our awesome colleagues here. If you're still interested in the EBAOS delay case, here is a questionnaire. You can sign up. Greg will have a new questionnaire that'll be up and about. We'll put on the interweb. But guys, thanks for being on tonight or today.
Thanks, Chuck. Thanks, Greg.
We'll see you guys next week. Greg tomorrow has a couple of his folks on today. Tuesday. So Aaron, you and I are on
James
tomorrow.
and Jonna were on today in my stead.
We're on Thursday.
When I'm on tomorrow. All right, so you guys have a great day. Bye-bye.